We've talked about some practical and business considerations, and now I'd like to turn to what I would call legal arguments that landlords and tenants may be able to assert as a defense to performance based on the four corners of the lease and common law theories. As always, the analysis needs to be done on a case-by-case basis, taking into account the specific provisions of the lease, the laws of the applicable jurisdiction, and facts relevant to the specific location. In my humble opinion, the best solution is a business one, and the court should be last resort. But these arguments certainly can be used as persuasive levers in your negotiations to get to the right outcome. So let's talk about the theories of force majeure, impossibility, and impracticability, and commercial frustration of purpose. Everyone is throwing around the term force majeure these days, but how effective of an argument is it really? You're looking at a fairly typical force majeure provision that I pulled from a lease that I was reviewing for one of my landlord clients. If there is, in fact, a force majeure provision in your lease, the first question is COVID-19 a force majeure event? Looking at this clause, I think one could fairly easily argue that the shelter-in-place orders are force majeure events as a governmental restriction or government regulation. But what about the argument that the COVID-19 virus itself is a force majeure event, which materially impacted the tenant's profitability and ability to pay rent? This clause does not specifically identify a pandemic or a virus as a force majeure event, but I bet we'll see more of that going forward. But there is a catch-all phrase, and other causes, except financial, beyond the reasonable control of the party obligated to perform. The question is, would that cover the virus itself as opposed to the SIP orders? Here in California, courts strictly interpret force majeure clauses. When particular events are enumerated as force majeure events, even where unrestricted catch-all language is used, a court will likely interpret the provision to capture only unlisted events that are similar to the listed events. A landlord's attorney would argue that COVID-19 is not similar to the listed events in this clause. The next inquiry is whether the force majeure event prevented the party from performing. If the business already was suffering, a tenant might have a difficult time arguing causation. But in the retail or service context, where a SIP order is in play, both landlords and tenants will have a much easier time making this argument. All this said, many force majeure provisions, like this one, specifically accept out the obligation to pay rent, and those provisions have been recently upheld in California courts. And this conversation obviously begs the question of whether these types of force majeure events could ever apply to the obligation to pay a sum of money. And in my view, the answer is typically no, unless the lease is specific to that obligation. Compared, say, to a tenant's continuous operations covenant, or a landlord's obligation to provide access to the property or maintain a retail center, which are directly being impacted by the SIP orders. That said, tenants may find success with a force majeure argument if it's dealing with a relatively unsophisticated landlord or a landlord that's not represented by counsel. The California Civil Code also contains a force majeure statute, Civil Code Section 1511. So if your lease does not include a force majeure provision, you may be able to rely on Section 1511, which excuses a party's performance if it's prevented by an irresistible superhuman cause, and there is no exclusion for payment of rent. The test is not limited to the equivalent of an act of God, but whether there is an insuperable interference that could not have been prevented by prudence, diligence, and care. A party still has to show causation, but again, it's another lever to use during negotiation. There's also the common law theory of impossibility or impracticability, which are virtually the same in California. These apply when it's impracticable to perform an obligation due to excessive and unreasonable difficulty or expense. However, the courts have held that the fact that a party's performance is more costly than expected or results in a loss is not enough. Again, the question is whether the obligation to pay rent is impossible. Arguably, no, but like in the force majeure situation, both landlords and tenants could argue that the shelter-in-place orders have made it impossible in some circumstances to perform certain covenants. The argument I like the best from the tenant's perspective is commercial frustration of purpose, which is potentially available where force majeure and impossibility are not. Commercial frustration is invoked when the intervening event destroys the underlying reasons for performing the contract, even though the performance is possible, for example, the payment of rent. To prevail on this theory, you would have to argue that the supervening circumstance is unforeseen, which is fairly easy to make in this case, that it's very severe, and the risk was not assumed by the party seeking to get out of the obligation, and as a result, the value of the contract was substantially destroyed. If you're a retail or service tenant, and your business was forced to shut down due to a SIP order, you would argue that the purpose of the lease, for example, to operate a restaurant or a fitness center, has been completely frustrated and the value of the lease destroyed, at least on a temporary basis. There are some interesting World War II cases on this topic. In one California Supreme Court case, the court held that where a governmental regulation does not entirely prohibit the business to be carried on in the leased premises, but only limits or restricts it, thereby making it less profitable and more difficult to continue, the lease is not terminated or the lessee excused from further performance. In Lloyd v. Murphy, the California Supreme Court did not allow a tenant to terminate a lease for an auto dealership where wartime restrictions imposed restrictions on the sale of new cars. In that case, the showroom could be used for other purposes. The landlord waived subleasing requirements, and the tenant was actually still selling new cars from other locations. Also, new cars could continue to be sold, and the landlord easily re-rented the space. In this light, I question whether a restaurant tenant who can continue serving takeout, even though it represents only a fraction of its business, can prevail using this argument. The other quirk here is that the supervening event is only temporary, so it will be interesting to see how the courts will deal with that nuance. It's definitely a gray area, which is why I advocate for a negotiated arrangement. In order to take advantage of the theories of impossibility and commercial frustration, you have to show that the risk was not foreseeable and that the risk was not otherwise assumed by the party seeking to be excused from the contract. With the knowledge that a pandemic is a real risk and may occur again, in other words, that it's now foreseeable, going forward, both landlords and tenants should be thinking about expressly addressing these risks in their leases. I expect to see some sort of pandemic clause, like a damage and destruction provision, that clearly defines the rights and obligations of the parties if this happens again. And the parties also should be taking a closer look at force majeure clauses to make sure they allocate risks fairly, or at least in a way that is consistent with their expectations. We should be forward-thinking, not just with respect to leases, but with respect to all of our contractual and business arrangements. Before I turn this over to Kendall, I just wanted to quickly touch on a few things to think about in the shopping center context, particularly from the tenant's perspective. Check to see if there's a co-tenancy clause requiring that a percentage of other tenants or a major tenant be operational as a condition to opening, or that might trigger a partial rent abatement. There might be an express or implied covenant in the lease that requires the landlord to provide a shopping center or a functional retail area open to the public, or to provide common areas and access to the premises and the center. It might be the case that the tenant can't operate its store consistent with the purpose set out in the lease.